Good morning, everyone. Welcome to Division 1 of the Colorado Court of Appeals. I'm Judge Craig Welling. To my left is Judge Daniel Taubman, and to my right is Justice Alex Martinez. We are Division 1 of the Court of Appeals. We have two cases set for our 9 a.m. docket this morning. First case is People v. Jamison, and I assume that counsel for that case is at the table. And then Bailey v. State Farm. Is counsel present for our second case as well?
Yes, Your Honor.
All right. Are counsel familiar with I know you're experienced practitioners here. Are you familiar with our procedures? Do you have any questions?
No, Your Honor.
Okay. I would just remind you that the proceedings today are being live streamed, so please be sensitive to that when discussing any information, because that may be of a sensitive nature, because that will be going out over the internet as well as archived on our website. There will be 15 minutes per side, and I would also ask that folks in the courtroom, if you have cell phones or other electronic devices, if you would please turn them off at this time so that they don't interrupt counsel during their argument. I would appreciate that. With that said, we'll go ahead and begin with People v. Jamison, 16CA0039.
Good morning, Your Honors. May it please the Court. My name is Meredith Rose, attorney registration number 45304, and I represent Mr. Jamison. Mr. Jamison appeals his convictions for first-degree possession of contraband and first-degree introducing contraband, making while confined. For the sake of time, I plan to focus my arguments today on Issue 2, prosecutorial misconduct, and Issue 3, which was merger. To begin, in order for Mr. Jamison to be convicted of first-degree possession of contraband and first-degree introducing contraband, the jury had to find that the object that was obtained from his cell at the foot of his bunk qualified as a dangerous instrument under the statutory definition in Section 18.8.2034. In other words, it had to be a knife or sharpened instrument readily capable of causing or inducing fear of death or bodily injury. The prosecution usurped the jury's role to make this factual finding by repeatedly offering his opinion that the object at issue was a dangerous instrument. The prosecutor repeatedly referred to the altered toothbrush as a dangerous instrument from opening argument to closing argument. And he also attempted to get his witnesses to qualify the altered toothbrush as a dangerous instrument and to actually give their opinion that the altered toothbrush met that legal standard. Mr. Jamison's theory of defense was that the object obtained from his cell was a craft tool. It was a craft tool that he used to cut cardboard, to make pop-up cards, and to alter clothing. So when the prosecutor repeatedly referred to this object as a dangerous instrument, it really cut right to Mr. Jamison's theory of defense. The people argue that any prejudice from these improper statements was cured because the trial court sustained defense counsel's 4 objections during the testimony of Investigator Redman. But really the prejudice in this case came throughout trial, from opening through closing, and the trial court only instructed the jury once to disregard the prosecution's questions and the witnesses' answers. A prosecutor can't give his opinion on a legal standard or give his opinion that a defendant is guilty, and he also is not permitted to ask questions that he knows will elicit an impermissible answer, and the prosecutor in this case did both. The misconduct here went right to the heart of the contested issue at trial, whether this object was a craft tool or whether it qualified as a dangerous instrument under the statutory definition. So the misconduct here really usurped the jury's role to make that factual finding and deprived Mr. Jamison of a fair trial. This warrants reversal.
Ms. Rose, if the conduct that you're describing was persistent throughout the trial, couldn't or shouldn't defense counsel at trial have made a motion for a mistrial?
Your Honor, the defense counsel did object during Investigator Redman's testimony, but defense counsel did not object at the rest of the time or made a motion for mistrial. That's something that was available to the trial counsel, but it wasn't done in this case. Moving to issue 3.
Well, before you do, I'm sorry, I didn't realize you were going to move. I think you agree that, many of the objections were sustained. There was a correction or an instruction with regard to one of them. Some of the references weren't objected to. And the concern is, since it's an abuse of discretion standard, you seem to sort of ball these things all together, whether preserved or unpreserved, whether sustained or the judge never did anything other than sustain and give the instruction. So I'm just wondering how you get to the abuse of discretion when the judge did everything, the trial judge did everything he was asked to do, or she, I don't know.
Your Honor, I think that some of the improper statements were not preserved by objection. That's true in this case. But during Investigator Redmond's testimony, by that point, it was really clear that the prosecutor was attempting to offer his opinion on this legal standard and also to get his witnesses to do that. And so at least at that point, the trial court was on notice that these statements were not proper. And yet the prosecution continued to offer his opinion and continued to try to get those answers. And then in closing argument, the prosecutor also told the jury that both the corrections officer and the investigator had personally believed that this was a dangerous instrument when they saw it. So I think, at least by closing argument, the trial court was on notice that it was error for these statements to be made. To address the issue of merger and whether Mr. Jamison's convictions must merge, it's a well-settled legal principle that possession crimes merge into greater crimes, where proof of the greater crime necessarily establishes proof of possession. In Patton v. People, the Colorado Supreme Court held that possession of a controlled substance merged into manufacturing because logic dictates that such control is required in the production of a controlled substance. Similarly, the United States Supreme Court in Ball v. U.S. held that a defendant's conviction for receiving an illegal firearm merged with his conviction for being a felon in possession of a firearm because proof of receipt necessarily includes proof of possession. Other cases from the Colorado Supreme Court that support this principle include People v. Abiodun, People v. Villapando, and People v. Cook. The same is true here. First-degree possession of contraband merges into first-degree introducing contraband, making while confined, because establishing that a defendant made a contraband object while he was incarcerated in a detention facility necessarily established that that defendant possessed that contraband object. It's impossible to have introducing contraband without also proving possession.
Ms. Rose, what's your response to the people's argument that that either there was no error or there was certainly not plain error based on the Etchells case?
Yes, Your Honor. The people rely on this court's decision in People v. Etchells to argue that the error here wasn't obvious, so it doesn't qualify as plain error. But it's not at all clear that the Etchells opinion actually addresses the statutory sections at issue here. Introducing contraband can be charged two different ways. Like Mr. Jamison, it can be charged under section 18.8.2031B as making a dangerous instrument while confined, or it can also be charged under section 18.8.2031A, which covers introducing contraband from the outside. In Etchells, the defendant was convicted of introducing cannabis, not making a dangerous instrument. And so it's not clear because the opinion does not identify the subsection which was at issue, but I think it's probably safe to assume that the Court of Appeals in Etchells was addressing this issue under section 2031A because of the way that they articulated their test. They actually said a greater offense is included in a lesser offense when establishment of the essential elements of the greater necessarily establishes all the elements required to prove the lesser. So it should have been clear to them if this was a case where the defendant made cannabis inside a detention facility that those two convictions would merge. Well, in this case, it was an issue of whether it was a lesser included offense. And so the Court of Appeals should have known under legal principle that possession crimes merge into greater crimes under the test that they articulated, and also under People v. Cook, which was a Colorado Supreme Court case from 1974, which held that simple possession of a narcotic drug was a lesser included offense of possession with intent to sell. Moreover, the lesser included offense at issue in Etchells was possession of cannabis, not possession of contraband. So it's not the exact same offense that we're dealing with here today. Because Etchells is not directly on point, because it's probably not addressing introducing contraband, making while confined, and because the lesser included offense is different, it's not dispositive of the issue that's before this court today, which is whether introducing contraband, making while confined, has a lesser included offense of possession of contraband. Because Etchells is not controlling here, this case is distinguishable from Scott v. People and this division's recent decision in Wambolt. In Scott, the issue before the Supreme Court was whether menacing is a lesser included offense of aggravated robbery menace victim. And the Supreme Court held that it wasn't plain error for the trial court not to know that those convictions would merge because there was a Court of Appeals case directly on point called Cisneros. And in Cisneros, they evaluated the menacing and aggravated robbery elements and looked at those crimes and held in a published opinion that they didn't merge. So it wasn't plain error in Scott. Similarly, in Wambolt, the issue was whether DUR is a lesser included offense of aggravated DARP. And at the time of Wambolt, the Colorado Supreme Court case of Zubiotti held that those two offenses did not merge. My understanding is that during briefing for Wambolt, the Colorado Supreme Court issued a decision in Rock, which directly threw into confusion and undermined the analysis in Zubiotti. So at the time of the trial for Mr. Wambolt and at the time of appeal, it wasn't at all clear that those offenses would merge, so it wasn't plain error. Here, there is no controlling authority that actually says that possession of contraband is not a lesser included offense of introducing contraband, making while confined. So this case falls under Reyna Abarca, where the Colorado Supreme Court held that DUI is a lesser included offense of vehicular assault DUI and vehicular homicide DUI, and held that that was plain error for the trial court to fail to merge those convictions. Additionally, the people argue that the error was not obvious here because Reyna Abarca, Rock, and Page were not announced until after Mr. Jamison's sentencing. But in Scott, the Supreme Court explained that a double jeopardy violation is not obvious when there's nothing to alert the trial court that the offenses would merge. Here we have the legal principle that possession crimes merge into greater crimes where proof of the greater necessarily establishes proof of possession. And we have cases like Patton and Ball, which stand for that principle. So the trial court should have been on alert that these two offenses would merge. Additionally, as this division noted in Wambolt, under the United States Supreme Court case Henderson v. United States, the question before this court isn't really whether the trial court should have known that these two convictions merge, but whether under the state of the law today, it's clear that introducing contraband has possession of contraband as a lesser included offense. And it was clear at trial that these two convictions should merge, but it is certainly clear today under Reyna Abarca, Rock, and Page that Mr. Jamison's convictions should merge.
And it's still an open question as to whether or not Henderson, we apply Henderson, right? We don't have any authority that we haven't picked whether it's time of review or time of trial yet, right?
That's right, Your Honor. The Colorado Supreme Court has granted cert in two cases, People v. Howard Walker, or Howard Walker v. People, and Garcia v. People, to address that question, but it's not settled in Colorado yet. I'd like to save my remaining time for rebuttal if this court has no more questions at this time.
Very good. Thank you, Ms. Rose.
Thank you.
Good morning. May it please the court. My name is Brittany Limes, registration number 48733 on behalf of the people. I'd like to briefly respond to defense counsel's prosecutorial misconduct arguments and then also move to the merger issue. To put it simply, the statements of the prosecutor when he was asking questions of Officer Miller and Investigator Redmond that were not objected to were not so tremendously flagrantly or glaringly improper that they warrant reversal under plain error. And the arguably improper questions that the prosecutor asked Investigator Redmond about whether or not this toothbrush met the definition of a dangerous instrument under Colorado law were objected to, sustained, and the court instructed the jury to disregard the witness's responses. Because the defense counsel didn't ask for a mistrial, didn't ask for further curative instructions, the trial court here did exactly what we want trial courts to do in this situation when it's faced with an objection to improper questioning, which is to sustain the objection and to instruct the jury. And this court presumes that the jury followed those instructions and disregarded any improper questioning. And I think it's important to point out that after the court sustained those 4 objections that all happened in a row, the prosecutor didn't ask those kinds of questions again going forward, and in closing argument properly argued and persuasively characterized the evidence to suggest that it had met its burden to prove that this altered toothbrush was a dangerous instrument and not a craft tool. And so, for the unobjected to comments, they don't amount to plain error. And for the objected to comments, the court did what it was supposed to do and neutralized and eliminated any prejudice from those statements. Moving to the merger issue, the Supreme Court's decision, Scott, lays out a perfect roadmap for how this court should address this issue. At the time of sentencing, Etchells had been on the books for over 35 years. It is directly on point. It addresses the same statute of introducing contraband that we have here. It did not limit its holding to subsection 1A or 1B. It addressed the entire statute. And it very clearly said that because possession is not an element that necessarily is necessary to establish introduction of contraband, these are not offenses that merge, and they are separate and distinct offenses.
I have a little bit difficulty understanding your statement that it covered both Section A and Section B. How do you know from that, from reading the opinion, was the defendant charged under both sections, or are you just saying that its language was general and didn't make it clear?
We don't know what section the defendant was charged under in Etchells. I think at the very beginning of the opinion, it says, when it's addressing the knowingly mental state, it says it's looking at subsection or section 2031, but doesn't go into A or B. And so I think that, and then when it's discussing the lesser included offenses, it doesn't differentiate between either of the 2 subsections. It just says, because possession is not, establishing possession does not necessarily establish introducing contraband.
So wouldn't it be controlling as to one subsection and merely dicta as to the other, except we don't know which?
I think that the way that the court wrote its holding, so the introducing contraband under 1A and then making while confined under 1B, since they both fall under 1, I think a reasonable interpretation of Etchells is that its holding applies to the entire offense for both ways that it's committed until this court overrules Etchells or decides that it's no longer good law. But at the time of sentencing, a plain reading and I think a reasonable reading of Etchells would suggest to the trial court that these are not lesser included offenses that don't merge. And under our Supreme Court's decision in Scott, that is as far as this court needs to go, because this issue was not raised at trial, and because Etchells is controlling law that is on point and goes against the argument that the defendant is making here, The error cannot be obvious and therefore cannot be plain. And so this court doesn't need to go any further than that in resolving this issue, just as the Supreme Court did. I'd also like to briefly address the issue raised in the reply brief about Henderson and whether or not we look at whether the error is obvious at the time of trial or at the time of appeal. I would argue that no matter which way, no matter which one is the correct one, and Judge Welling, as you asked, the Supreme Court is currently addressing that question. I would argue that it's still not obvious, even now at the time of appeal, particularly given the state of law and looking at whether two offenses are included in another is still evolving. In Rock, the Supreme Court disapproved of its rationale in Zubiotti, which had been announced 7 months beforehand. And as this panel addressed in Wambolt, this is an area of law that is still not clear. And so under either time frame, this error isn't obvious, and a merger is not required here.
Ms. Limes, I'd like to go back to our discussion about the Etchells case. Even if your interpretation of Etchells is correct, wouldn't it have been rendered no longer good law based on the Colorado Supreme Court's more recent decisions in cases like Patton and Biodun?
I think that a couple of responses to that. I think that Etchells has never been expressly overruled, and I think that's one of the reasons why we want to have the contemporaneous objection and the argument made at the trial court to say, hey, looking at this line of cases, it's possible that this is no longer a sound argument. But that simply is something that didn't happen here. And trial courts are bound to follow binding precedent that this court announces on appeal until it's overruled or unless the parties below have made a persuasive argument that it is no longer good law. And so without an objection, I think it's under plain error review. We don't expect trial courts to sua sponte decide that decisions of this court have been overruled without an objection. I think that following stare decisis, that's a lot to ask trial courts to do without the benefit of arguments from counsel or an objection at trial. I'd also like to point out that while in Etchells they were charged with possession of cannabis, both subsections 1A and 1B reference marijuana as contraband that can fall under that statute. And so I think that that distinction, that's a distinction without a difference for Etchells in this case. And that given the language of Etchells, it is binding and controlling until it is overruled or until it is properly raised in the trial court and assessed under the new standards. If this court doesn't have any further questions, the people would respectfully ask this court to affirm.
Thank you. Ms. Rose, you have 2 minutes and 14 seconds remaining.
Just to make 2 brief points. I think it's clear from reading Etchells that it's not controlling here because it doesn't specify the subsection. And I think logic dictates that what was at issue in Etchells was introducing contraband from the outside, not introducing contraband by making it while somebody is confined, because the court articulated the right test for determining whether these 2 convictions would merge or whether possession would be a lesser included offense. And also it's not binding because the lesser included offenses were not exactly the same. So a trial court looking for guidance on this issue wouldn't necessarily know that, or wouldn't identify Etchells as a case that really dictated the outcome here. Also, to respond to your question, Judge Taubman, I don't think that Etchells is good law anymore, given the evolution and the way that we look at possession crimes and how they merge into greater crimes when proof of possession is necessarily established by the grader. Your Honors, the error here was plain at trial under well-settled legal principles. It is also plain on appeal now under those same principles and under Reyna, Barca, Rock, and Page. And if this court has no further questions, Mr. Jamison respectfully asks the court to reverse his convictions, or at a minimum to merge his convictions for possession of contraband and introducing contraband, making while confined. Thank you.
Very good. Thank you, counsel. Thank you to both counsel for their arguments as well as their briefing on this case. The case will stand as submitted, and a written opinion will issue in due course. So we'll now turn to our Bailey versus State Farm for the appellants.
May it please the court. My name is Keith Fuselli, and I am privileged to appear before this panel on behalf of Bruce Bailey. The heart of this appeal really lies with getting the benefit of what you pay for. It's really about getting the benefit of your bargain. And in this case, the bargain is this. You purchase underinsured motorist coverage for a promise. And the promise is, if X happens, we will pay Y. And with 104-609 amendments in 2008 that I'll touch on in a moment, the language of that amendment, something this court has called plain and unambiguous, is if you are injured and your damages exceed the amount of legal liability coverage, then we will pay. In this case, Mr. Bailey's damages were $300,000. There was $100,000 in liability coverage, and therefore, under 104-609, State Farm is required to pay. That's the benefit of the bargain that Mr. Bailey received. When he paid money for this promise, the money was, if I'm injured and my damages exceed the amount of legal liability coverage, then you pay. And it doesn't matter if the tortfeasor hits the lottery and pays, and it doesn't matter if some corporation decides for its own reason to pay. The benefit of the bargain that was paid for under the plain and unambiguous language of 104-609 is, if X happens, then we will pay under Y. And that's exactly what occurred in this case.
Mr. Fusilli, how is your argument consistent with cases that have held that the purpose of underinsured motorist insurance is to make sure that a driver who's in an accident who's not at fault doesn't suffer financially because the other driver was uninsured or underinsured?
So this position is entirely consistent with that. Obviously, there is a long line of cases from this court that talk about the purpose of underinsured motorist coverage being to place someone in an advantage or in the position they were in if there were not enough insurance coverage to cover the losses. But just because there's a long line of cases that back up that just proposition does not negate from the equally just proposition, which is you get the benefit of your bargain. It was interesting, I was talking.
The benefit of the bargain here would have actually left him holding the bag for $100,000 because there was $100,000 in coverage, $100,000 in UM, and $300,000 in damages. But as a result of the promise and to what amounts to increase the coverage of the tortfeasor, your client ends up getting made whole, something that in the absence of that promise you would not have got. Once that promise is made to the tortfeasor, how is he still underinsured?
He's underinsured under the plain language of 104-609 as amended in 2008, because the plain language of the statute says, this coverage shall cover the difference between legal liability coverage and your damages. And one of two people in this case is getting a windfall, I will concede. It is either State Farm Insurance Company that gets a windfall in the form of insurance premiums that were for nothing, or Mr. Bailey gets a windfall in the form of the benefit of the promise that State Farm agreed to enter into when it took his insurance premiums. And I would direct the court's attention to the language contained in Tubbs v. Farmers Insurance Exchange. Regardless of what amount, if any, and this is a quote, Your Honors, regardless of what amount, if any, the insured receives from the liable party, the UIM insurer is required to pay for damage in excess of the tortfeasor's legal liability limit. And this sentence, I believe, hits the nail on the head. This is precisely the coverage that the UIM insurer agreed to provide in exchange for a premium. And that's on page 927 of that opinion. The opinion goes on to state, it is irrelevant whether and in what amount the insured recovers from the underinsured motorist. It is irrelevant because
Right, because the way that they amended the statute in 2008, it explicitly said that there is no set-off for what is recovered from the tortfeasor. So if you were able to recover the $200,000 from, you had the $100,000 in policy limits, and you were able to recover the extra $200,000 from the tortfeasor, that does not relieve the UM carrier from liability, but you didn't recover it from the tortfeasor. You recovered it from his insurance company. Doesn't that matter?
I don't believe that it does matter, Your Honor. And in some respects, if there were two different insurance companies, it may make the analysis a little clearer in my mind. If State Farm insured tortfeasor Hoover, but Mr. Bailey was insured by American Family, just because State Farm makes a gratuitous offer to pay for its own reasons, then American Family gets a windfall under those circumstances. So our position is that under the clear, plain language of 104-609, State Farm's gratuitous offer to pay is not legal liability insurance, and because it is not legal liability insurance, Mr. Bailey is entitled to collect under the underinsured motorist policy. And even if the court disagrees with me in that respect, probably more critically important here is the waiver issue. And what occurred in this case, and I hate to say it because it may sound like I'm whining, but what occurred at trial was not fair. We spent half of our time at trial arguing about an issue that if State Farm is right and this underinsured motorist policy isn't at play, is totally and completely legally irrelevant. Half of the time at trial was spent rebutting affirmative defenses for the underinsured motorist policy at issue here. And all of the parties in this case proceeded to trial under the trial management order, under the assumption that if Mr. Bailey's damages exceeded $100,000, State Farm would pay. Fortunately, sometimes the law provides a remedy to address inequities and address things like fairness. And in here, the remedy comes from the Dinosaur Park v. Tello opinion and State ex rel. Ruthers v. Johnson Law Group. Where a defense is not asserted in defendant's responsive pleadings or intentionally or actually tried, the defense is waived. And going back to Judge Welling, your point earlier about the fact that this is State Farm, it's actually critically important here that it's the same insurance company. State Farm made the strategic decision a week before trial to send a letter saying, we'll pay whatever the verdict was. State Farm then had an obligation under Rule 15 to amend its answer so that this issue could have been raised pre-trial. Instead, Mr. Bailey suffered great prejudice with the character assassination that occurred related to issues that were completely and legally irrelevant to the underlying claim. And I note the language from Ruthers v. Johnson Law Group, where a division of this court said, to hold otherwise, in other words, to allow a defendant to amend its answer post-trial, which is exactly what is occurring here, would allow defendant to avoid the consequences of their failure to plead the defense.
Well, I'm just not quite sure how, I understand how you convert what really was a motion for judgment. And appreciating the frustration of trial being consumed by things that subsequently were not pertinent at all. But how do you convert that into a defense? Why should we not simply regard it for what it was? A request that the judge figure out where the judgment should lie.
Well, that's a great question, Your Honor, and it goes to what the definition, what an affirmative defense is or is not. And we cited in our brief that an affirmative defense is, even if all of the allegations contained in the complaint are true, the affirmative defense defeats coverage. And here, the allegations in the complaint and the trial management order were, if our damages exceed $100,000, this policy at issue comes into play. So it is our position that it was an affirmative defense and that State Farm had a duty to amend its answer under Rule 15. Otherwise, we suffered great and severe prejudice by what I hesitate to call was gamesmanship by State Farm. They knew very well what they were doing. They knew they were going to come into court and commit character assassination of Mr. Bailey on an issue that was totally irrelevant to the underlying tortfeasor's claim. And they got the benefit of that. And it's our position they had an obligation under both the Tello case and Johnson Law Group to amend their answer pursuant to Rule 15. And with that said, I'd like to reserve the remainder of my time for rebuttal.
Very good, thank you.
Good morning, Your Honors. May it please the Court, Carl Chambers, Attorney Registration 17754, appearing on behalf of the appellee in this particular case. And this is actually really a fairly simple case. It's a simple case of whether or not a plaintiff can recover underinsured motorist benefits when they've been fully paid the damages by the liability insurer, as occurred in this particular case. And to answer that question, you simply have to look at what the purpose of UIM coverage is, as Judge Welling already commented on. The purpose of UIM coverage is to provide safety or protection for a financially irresponsible motorist, or to cover the difference between what the at-fault party pays and what the actual damages are. Here, that has taken place. It's undisputed. The damages that the jury determined have been fully paid, including all costs and all prejudgment interest. There are no additional damages for the plaintiff to recover in this case. And that's essentially what they're asking this court to do, is to order some type of phantom damages or windfall damages that have never been determined to have occurred in this case. What they're asking the court to do is, yes, I already got my judgment for the $300,000, but now I get another $100,000 on top of that for no basis, and having no basis for doing that at all.
Mr. Chambers, just out of curiosity, does the record reflect why State Farm offered to pay whatever judgment might be obtained by the plaintiff? We don't usually see insurance companies making such offers in these kinds of cases.
You know, there's nothing, I don't think, in the record. I have represented State Farm for a number of years. I know that is something they do on occasion. There are a variety number of reasons for doing that. potentially to protect their insured from something that happened in this particular case, an excess verdict, so agreeing to do that so that their own insured is not subject to any type of personal financial loss because of their decision not to pay something prior to that time. So I think other than that, there's nothing in the record that would reflect why that decision was made. But the fact is, they did make that decision, they agreed to pay for it, and in fact, they have paid that full judgment. So I don't think this case falls in the context of what the purpose behind UIM coverage is. And although not all that particularly necessary for resolution of this case, I mean, the reference to the fact of Mr. Bailey paying premiums for this policy is incorrect. This was his mother's policy. Mr. Bailey never made premium payments on this policy. I understand that you have...
State Farm received premium
Correct,
payments
yes,
on this policy.
Yes. I mean, we're not arguing that the policy wasn't enforced and they weren't paid for, but to suggest that Mr. Bailey paid years of premiums to obtain this coverage is not accurate. It was his mother's policy.
And you're talking about the purpose of coverage and the potential for a windfall here. You would agree that under the 2008 revisions to the statute, if there was an excess verdict so we have assume that this agreement wasn't in place and there's a $300,000 verdict with $100,000 in coverage, if the tortfeasor and if the plaintiff ends up collecting from the tortfeasor the excess damages award, they're still entitled to collect under the policy, right?
I don't believe so, Your Honor. I mean, I still don't think that they would be entitled to collect $100,000 when the full amount of the judgment has already been paid, because there are no other damage to recover. If, in fact, that were to occur, if you were to say that they would still be entitled to an additional $100,000 in coverage despite that payment, then I think you would need to look to the language of the insurance policy, which we argued. There's two particular provisions within the insurance policy that I would think would address that issue. The one particular issue deals with the policy language. It's found at page 849 of the appellate record, which is the State Farm insurance policy, which states, "We will not pay any damages that have already been paid to or for the insured by or for any person or organization who is or may be held legally liable for the bodily injury." So under that provision, if the liability insurer paid all the damages that were awarded by the jury, this provision would indicate that State Farm would not be responsible then for payment of the UIM benefits because they had already been paid by the person who was legally responsible to cover those damages.
While that may be true, you've talked about the purpose, but you really also have to deal with just the plain language of the statute. And I'm actually more curious about your plain language argument that would allow that provision to control. Because at least when you're talking about exceeding the legal liability coverage, and you get into the question of whether the offer or the willingness to pay more than the original coverage is also legal liability coverage. But if you're talking about recovery not from the insurance, but rather from the tortfeasor, I don't understand how that fits with the plain language of the statute. Perhaps you could address that.
If I'm understanding your question, Your Honor, and please correct me if I'm not, if the payment comes, you're saying, from the individual tortfeasor as opposed from the liability insurance company, does it change the result?
No, what I'm asking you to do is focus on the plain language argument, whether that is to support your argument that the plain language, not just the purpose, compels a result here, or that would also compel the result that you're talking about if the recovery were not from the legal liability insurance, but directly from the tortfeasor.
I think the statutory language, and if we're talking similar, consistent with the language of 104-609, which indicates that the coverage described in paragraph A above of this section shall be in addition to any legal liability coverage and shall cover the difference, if any, between the amount of the limits of any legal liability coverage and the amount of damages sustained. So with that particular language, I still think that the purpose of that statute is to provide for the payment of any damage.
I appreciate the purpose argument,
Uh-huh.
but I'm not sure how you get to the purpose argument unless your statutory language is supporting that, or at least unless the purpose is simply helping you to understand this statutory language. Statutory language doesn't seem to give any room for some exception for recovery from the tortfeasor, does it?
And also, just to add on to that, doesn't the last sentence of subsection C undermine your argument with respect to what the purpose is? That's the language I was getting at. If this recovery, if the excess judgment was recovered directly from the tortfeasor, doesn't the last sentence of subsection C indicate that there would not be a set-off? You would still be able to recover from your UM even if the recovery was from the tortfeasor.
In that particular situation, Your Honor, that using that statutory language, that's not the fact pattern that we have now because the statute's changed. So I think we have to apply the statute as it is in place now.
Which
But
is
if
what
we-
I just described, which says that there is no set-off if you recover it directly from the tortfeasor, right?
Correct. And so under that scenario, then there would potentially be a conflict within the statutory language and the language within the State Farm policy, which I previously indicated, which indicates if they pay something, if some other person pays for the damages, then they cannot recover that a second time for UIM coverage.
But that provision of the policy directly conflicts with the last sentence of subsection 1C, right?
I would agree with that, yes, Your Honor.
So that would be unenforceable.
Yes, I mean, certainly that's what the court would, I mean, an issue would be raised, but yes, I mean, that would have to be litigated, and I'm presuming the court would come down with a decision that it's in conflict and would not be applicable.
Why didn't State Farm, if this is your theory, that essentially the liability coverage here was increased from $100,000 to unlimited coverage, why didn't State Farm move to dismiss the UM claim against it prior to trial?
I think at that point in time, they had made a decision that they had prepared for trial. They felt that it would maybe be of some benefit to have two attorneys supporting the defense of the case, and that therefore they could proceed. The plaintiff had the option at that point in time as well to dismiss the UIM claim with the assurance that any damage would be paid, and they elected to go forward pursuing the UIM claim at that point in time. So I think there were...
Well, but the plaintiff doesn't necessarily want to do that because, well, this gratuitous promise was made in the event that there's some defect with it and they don't end up actually performing on that promise, the plaintiff still wants to have the UM coverage. It's State Farm that knows that there's no potential liability for it under the UM portion prior to trial. So why isn't it incumbent on State Farm, if they want to maintain this position at the time of judgment, to request to have the claim dismissed?
Well, I think there's still the same concerns on their part. I mean, the assurance letter indicates that they will pay for it, but that's assuming that the defendant continues to cooperate throughout the process. So, I mean, there's still that concern that State Farm as UIM carrier would have to deal with it as well in terms of going forward and whether or not they agree to cooperate and have that actually paid at the end of it. But my position is I don't think that's necessarily all that relevant to deciding the issue that we have now. And what the issue that the court is confronted with now is that we have a judgment that's been entered, the full amount of the judgment has been paid, and so can we go back now and say that the plaintiff should get an additional $100,000 when all their damages have already been covered and paid in the case? And I'm not aware of any statute or case law in Colorado that would allow for such a scenario to take place, and an individual could recover damages that are non-damages, that have not had any type of, suffered any consequences from. So that's
What were the limits of the legal liability coverage?
$100,000.
Isn't that the very phrase that's used in the statute, is the difference between the judgment and the limits of legal liability coverage?
That's correct, Your Honor. But in this case, it's just nonsensical to suggest that the $100,000 that was paid if that was all that was paid, then they step up and they pay the additional amount, that they can still come in and get UIM coverage. I mean, essentially the assurance letter, although it's not called legal liability coverage, I mean, essentially becomes legal liability coverage to pay the full amount that's awarded. I mean, I think some sense has to be applied to the situation. And I don't think you can take a situation and read that language and say, okay, he got everything he was entitled to, but there was really only $100,000 in, quote, legal liability coverage, so we're going to give them another $100,000. It just doesn't make sense. And if that were to be the case, if you were to step in and say, well, there's only $100,000 in legal liability coverage, so you need to pay your $100,000 in UIM coverage, then I think going back to the terms of the policy, they would effectively indicate that either State Farm's not required to pay that under the one provision, or under the reimbursement provision, if they pay the $100,000, then they just have to turn around and pay it back to them again, because that $100,000 in damages has already been paid by the person that was at fault. I mean, that's the whole thing, is to hold the person financially responsible that was at fault for the accident. That's occurred in this case, and I don't think that this is the type of situation where, essentially phantom damages or windfall is warranted under the particular facts of the case.
And when a policy ends up getting invoked and has to pay, does the carrier then have a claim against the tortfeasor to go and recover?
They do. They potentially, yes. I mean, they have a subrogation claim. Depending on the financial status of that person or whatever, they may or may not decide to pursue that.
But here, that ends up going away because you don't have anybody that you can potentially turn to, do you? I mean, it's kind of an odd situation.
There's no one that needs to be turned to because they haven't paid the $100,000, so they don't need to subrogate for any reason because that full judgment's already been paid. So there's no need to apply any type of subrogation. Just briefly, John, is on the last point in terms of the issues that were raised, in terms of defense of the case, I don't think a majority of the trial devoted to these issues concerning Mr. Bailey's income. They were, I think, limited, and I think they still would have been an issue had State Farm not been part of it, because he had initially presented a claim for wage loss. I think that would have gone to his credibility, and the evidence still could have come in through that.
Very good.
With that, we would request that the judgment be affirmed. Thank you very much, Your Honors.
Thank you. 4 minutes and 25 seconds.
Thank you, Your Honors. One point that I thought was interesting is that we were actually put on the clock at trial here because we were under such tight time constraints. And the issue that Mr. Chambers raised about 2 defense attorneys is exactly the point. We were at trial being put on the clock, dealing with not one but 2 different defense attorneys. So every witness is being cross-examined by 2 different defense attorneys, and it really did extend the point of the trial, or the time of the trial, considerably. To Judge Talbaum's question regarding why did State Farm give this comfort letter, the reason they did that is because there were prior policy limits demands made, and if they didn't do that, then their tort fees, their insured, would have a claim against them for bad faith under the Basher line of cases. So it is a self-interest on State Farm's part to do that when they have turned down prior policy limit cases, demands. Mr. Chambers said that he's not aware of any case law or statute that would sort of dictate the outcome in this case. And I'd like to read a passage from Jordan v. Safeco, which I would submit to this court is outcome determinative of the issues before this court. Before the 2008 amendments to that section of 104-609, The statute required UIM coverage for damages in excess of amounts paid pursuant to a tortfeasor's liability policy. As amended, however, 104609 requires coverage for amounts in excess of a tortfeasor's liability policy. The amended statutory language is plain and unambiguous. The insurer's obligation to pay benefits is now triggered by exhaustion of the tortfeasor's limits of legal liability coverage, not necessarily any payment from or judgment against the tortfeasor. And that's at page 449 of that opinion. The comfort letter, we haven't spent much time on it, but the comfort letter cannot be legal liability insurance.
Why not?
Because the statute 104609 cites to Title 42 and provides the requirements of what legal liability insurance is, one of which requires a certification with the state. That never occurred here. So for those reasons, it is our position that it is not legal liability insurance and is no different than if the tortfeasor won the lottery or had a rich uncle or somebody decided to pay this verdict. It is nothing more than a gratuitous offer to pay by an insurer for its own benefits and is not legal liability insurance. And even if it were, the waiver arguments in this case, we hope, are compelling. Because first of all, I would strenuously disagree that even if this would not have been an issue, State Farm would have been able to attack Mr. Bailey's credibility based upon representations made in an effort to settle his claim pre-suit under Rule of Evidence 408, right? But the point of the matter is, Mr. Bailey was severely prejudiced by all of this information that came in. It was clearly a strategic decision on State Farm's part, as admitted. They liked the idea of having two lawyers. They liked the idea of coming in and addressing head-on these affirmative defenses that now are legally irrelevant. And for those reasons, Your Honor, we would ask that this court reverse the Court of Appeal, unless the court has...
I have one more question.
Yes, sir.
Typically, there would be a subrogation right for the UM carrier to recover against the tortfeasor if it
Yes.
had to pay.
Correct.
But because of the way that this is structured and the windfall that is being sought, that vanishes, right?
I'm not sure if I suppose there would be no reason why State Farm, if they pay on the $100,000 policy here, could not go after Mr. Hoover personally for that $100,000. There was no release signed. There was nothing extinguishing State Farm's right to do that. They have every ability to do that if they want. Now, they'll probably get sued by Mr. Hoover for doing that, but they can do that if they want.
Even though the judgment's been paid in full and then some.
Yes, nothing would prevent them, if they pay the $100,000 on the underinsured motorist claim, that judgment would not extinguish State Farm's right to go after Mr. Hoover personally for those monies.
Okay, thank you.
Thank you, Your Honors.
Thank you, counsel, for your arguments today as well as your briefing on this case. The case will stand submitted and an opinion will issue in due course. That ends our 9 a.m. docket as well as today's docket for this division. So we will be in recess if the bailiff would so announce.